Some people in California may not want to prepare a trust. Maybe they don't want to spend the money, or they think their situation is really simple and that it doesn't require much work. So they'll create a will instead. And we have videos talking about why we don't think this is a good idea. But in some states like California, the law provides that you can do a handwritten will on your own. This is called a holographic will. Again, we don't recommend this, but enough people have asked me about it that I decided to do a video about this, about what a holographic will is and how it works. Before I go into that, I just want to ask you if you'd like to subscribe to our free monthly newsletter. We have a whole lot of tips about estate planning and also local events that you might enjoy. So you can click the button below to subscribe. Okay, so first let's define a few things. So I mentioned that a holographic will is a handwritten will and it doesn't follow the rules of other wills. And then you also need to know what is a testator. So that's the person who's writing, who's making the will. So there's some requirements to make a holographic will in California and have it be valid. The first one is that the testator, the one writing the will, they have to sign the will. And also the material provisions must be in the testator's name. So what are material provisions? Well, you need to say who are receiving the assets, the beneficiaries, who's managing the will, that would be the executor, and also who are you naming as guardian of your minor children, if that applies. Now, you can use a pre-written form as a holographic will where you just fill in the blanks. You write in those material provisions. But those things themselves, those provisions need to be in your own handwriting for it to be a valid holographic will. Okay, also the testator must be at least 18 years old and they must be of sound mind. So that means they're aware of the consequences of their actions and they weren't coerced into signing anything. And the document must say that the testator is intending to create a will. Maybe it says something like, I hereby sign my last will and testament, or something like that. So what is not required for a holographic will in California, but are required for other wills? For a holographic will, no witnesses are required, whereas for a regular will in California, or a pour-over will, 2 witnesses are required. And then also for a holographic will, strangely enough, the testator, when they sign, they don't have to put the date that they signed. Now, it's a fabulous idea to put the date, but you're not required to. I find that kind of strange. Why would somebody want to write a holographic will anyways? Well, it's possible they want to write out exactly what they're thinking and they think only they can write it out accurately. Or maybe they don't even want to spend any money on any forms. Or perhaps they're about to die and they realize they haven't done a will yet and they better write one out. So, as I mentioned, we think this is a really bad idea. Handwritten documents can always be contested in court. Just because it's allowed under California law doesn't mean that you should do it.
Hello, did you know that my mom helps people all the way through the state of California from top to bottom? Go give her a call.
Also, the holographic will might be vague or ambiguous. Maybe the testator knew what they were thinking, but what they wrote out wasn't that clear to everybody else. That often happens, actually. Other people reading the will could be very confused about the testator's true intentions. And keep in mind, if you're doing a will in California, whether it's a holographic will or a regular will, it's still subject to the probate court administration process. And that is a super duper pain, right? It's expensive, it's time consuming, it's public. In fact, I have a video called 10 Things I Hate About Probate. So if you're not convinced about how bad probate is, please go watch that video and hopefully I'll convince you. Right, so there's 2 famous people in the recent past who unfortunately did holographic wills, and this led to all sorts of problems with their family. Let me tell you about them. So the first one is Howard Hughes. And you may have seen the movie The Aviator, which depicted the life of this eccentric billionaire. It was played by Leonardo DiCaprio. So what happened was in 1968, Mr. Hughes wrote a 2-page holographic will while he was on a flight. Now the will was pretty hard to read, but he basically left his estate to various medical institutions to fund medical research. Now, when Mr. Hughes died, there were a lot of questions about the validity of that will. Mr. Hughes's signature on that will differed from other samples of his signatures. And he also might have spilled acid on the will, which distorted a lot of the writing. And there was also some question about his state of mind while he was writing the will. There were years of court fighting, and finally in 1978, a jury ruled that the holographic will was legitimate. But this was appealed for years. What a mess. Don't let this happen to your family. Person number 2 was Aretha Franklin. Now, I totally love Aretha Franklin's music, but unfortunately she didn't do as good of a job on her estate planning. When Ms. Franklin died in 2018, her 4 sons looked for estate planning documents, and they found 6 wills stuffed in sofa cushions, locked in briefcases, and hidden under piles in her office. Some pages were torn or words were scribbled out, and her distribution desires varied widely between the different versions of the wills. Needless to say, it took a long time and a lot of money to sort all of this out. It involved battles between her sons, claims against the estate, including her ex-husband and music executives. Like Aretha Franklin says, you gotta think before you do something like that. So here's the moral of the story. Even if you think you have a simple and super straightforward situation and you think you can do a will yourself, please don't do it. I've had many people over my 15 years of practice come to my office and say, "Oh, Ellen, my situation is so simple," but usually it's not. They just haven't thought through how their wishes might be misinterpreted or what tax issues might arise and what could otherwise lead to confusion among the beneficiaries. Also, I hope these examples show why you shouldn't write on your current estate planning documents and expect those little chicken scratches to be valid. I've had clients come in with a revocable trust and they've crossed some things out or they've written other things in the margin. Just be aware that those types of changes usually aren't valid under California law. You'll need to work with your estate planning attorney to prepare an amendment to your trust to make those changes effective. So if you're thinking of preparing a will in California, I urge you instead to prepare a revocable living trust. This doesn't go through probate, and it doesn't have the huge hassles I've described in this video. To learn more about revocable trusts in California, please watch my video, What Should an Estate Plan Contain? And I'll see you over there.
Did you know that my mom has a monthly newsletter? Subscribe by clicking below.